This is WTIC's Law Talk, a project of the Hartford County Bar Association. If you have a legal question, call now at 522-WTIC, 800-966-WTIC. And now it's time for Law Talk on WTIC News Talk 1080 and WTIC.com.
Yes, it is. Good afternoon, everybody. Welcome to Law Talk. I'm Attorney John Metoulis from the Hartford County Bar Association. My pleasure to join you these Saturday afternoons if we're not bumped off by a UConn football game. And what we do is we try to share some legal information, some legal knowledge, and help you navigate your way through that thicket of laws and rules and regulations that, left to their own devices, will bedevil any one of us. We're here until 4 o'clock today, and the best part of this program is we get to take phone calls from you at 860-522-WTIC, 1-800-966-WTIC. If you're using a device where the letters are sort of small and maybe blurry, that translates to 9842. So that's 1-800-966-9842. My guest today is Attorney Carmine Perry from the law firm of Sepega Daly Pope. I'm going to tell you more about Carmine in just a minute, but this is a really good program for you to stick around and join us. In the past, when we've done programs about probate and elder law, they've been very popular with the listeners, and I think that a lot of our folks have interests in those areas. Well, the next step in the progression is when there are disputes in those areas, oftentimes they have to be resolved by litigation. So we're going to get into will contests. We're going to get into contested conservatorship proceedings. We're going to talk about nursing facility litigation, including how you as an innocent loved one can possibly get stuck for a lot of money if you're not careful. We're going to tell you how to avoid that. And we're going to talk about Department of Social Services fair hearings and other topics of interest to you. So first of all, let me tell you a little bit more about our guest. Attorney Carmine Perry is a graduate of Sacred Heart University and Quinnipiac University School of Law here in Connecticut. For the past 6 consecutive years, New England Super Lawyer magazine has named him a rising star in the area of elder law. He is a member of the Probate Court Rules Advisory Committee here in Connecticut. He is a frequent speaker to professional groups on topics such as the ones that we're going to discuss today. He's also a member of the Board of Editors of the Connecticut Bar Journal. He's a member of the Connecticut chapter of the National Association of Elder Law Attorneys, and he has numerous responsibilities for the elder law section of the Connecticut Bar Association, where he is the secretary. He's also a member of the Estates and Probate section, and more and more. So, Carmine, without further ado, welcome to Law Talk, and thanks for joining us this afternoon.
Thank you for having me, John. I appreciate it.
Well, glad to have you with us. We're going to be getting to listener calls. I see that there's a couple that are building already. Just wanted to let you know it is an excellent opportunity to get Carmine's expertise in any of these matters. We're only here until 4 o'clock today. So if you're listening and thinking about, well, should I give him a call? Should I wait a little bit? It's always better to call a little bit earlier in the show rather than later, because it makes it more likely we'll be able to get to your question and help you directly. Let's get started with a hypothetical that we chatted about just a little bit off air, Carmine. Aunt Tilly passes away, and the family discovers that she did a will about 6 weeks before she died, and notwithstanding all of the loving relatives who doted upon her, she left her entire estate in that will to a television preacher that she used to watch on TV. So the family's gathered in your office across your desk. They want to know what they can do about this. What can they do?
Yeah, that happens frequently. We get that question a lot, and we have a lot of consultations regarding that. And there's a number of questions. One of which is, do you know of a prior will? Do you know?
Why is that important?
And that's important because if you believe that you are a beneficiary under Aunt Tilly's estate plan, then that will dictates what Aunt Tilly wants to do with her assets. And if she had a prior will, and you knew about it, you'd know if you were that beneficiary.
So let me throw this phrase in here because I heard this somewhere. Maybe this applies. It's called the Doctrine of Dependent Relative Revocation. Did I get that right?
You got that right.
Tell our listeners more about that.
So the Doctrine of Dependent Relative Revocation is if you have a will that's admitted to probate, let's say it was drafted in 2016, and that's invalidated, then you go back to a prior will. So you keep sort of peeling the onion back, so to speak, starting from the most present document and going backwards.
Now, we've got this group of Antilles heirs at law sitting in front of you, angered about this bequest to the television preacher there, and what are the different ways? I assume that they would have to challenge this will and somehow get the court to declare that it was invalid for some reason in order for them to participate in Antilles' estate.
Right.
So how do you do that? What are the legal theories? What are the factual obstacles? Tell us more.
Sure. So even before we get there, first we've got to get into court. So you're going to file an objection in court to the admission of what would be called the purported will, the one to the evangelical preacher in whatever state that is. You get yourself into court, and then you advise the court that you have an objection, and you set up a scheduling order wherein you dictate different times where you would depose certain witnesses, get some evidence, and you're eventually going to get to trial. Now, to answer your question, there are a number of theories to invalidate a purported will. Three that I use mostly, and the first two of the three that I always use, or almost always use, is one that, in this case, Aunt Tilly lacked requisite testamentary capacity, and I'm sure we're going to get into that.
Yeah, we'll talk about that more in a minute.
Right. The second one is that Aunt Tilly was unduly influenced to execute the document.
Uh-huh.
And we hear that frequently. That one comes up, generally even more than capacity. You'll get a call that this person signed a document and he or she wouldn't have done it without another person influencing them. So that's undue influence. That's the second one. So those are the first top two, without a doubt, unequivocally. The third one, sometimes it comes, is inadequate formalities.
Technical defect.
Agreed. Exactly.
Don't see those too often.
You do not, although once in a while...
homemade will?
That once in a while it happens, and it's shocking. And inadequate formalities when there's a technical defect not consistent with the law, the requirements of the law. It once in a while comes up, and that resonates to a judge because it was done inconsistent with law.
We're going to follow up on this after the break that we're required to take in just a moment, but we're going to hear more about what happens with Aunt Tilly's will in favor of the clergyman that she never met. We'll talk a little bit more about that, some of the other topics. My guest is Attorney Carmine Perry from the law firm of Cepeda Daly Pope. I'm Attorney John Metoulis from the Hartford County Bar Association. We're here until 4. You got a question? Give us a call at 860-522-WTIC, 1-800-966-9842, and we'll be back with more of Law Talk after this.
So fine.
All right. Welcome back to Law Talk, everybody. For those of you that have been following the Nobel Committee, that is Bob Dylan, America's latest Nobel Prize winner for literature, and apparently a highly controversial decision in the part of some people who wondered why a folk rock poet would end up winning the literature prize. But anyway, we're going to be doing a little bit of that today in celebration of the fact that an American has won the prize for the first time since 1993. All right, back to the saga of Aunt Tilly and the will that left everything to the television preacher. My guest is Attorney Carmine Perry from the law firm of Cepeda Daly Pope. Carmine's practice is limited to litigation in the probate court and the superior court involving matters exactly of the sort that we're talking about today, and this is a great opportunity for you to get some expert advice if you've got any of these issues pending, and we'll be happy to hear from you at 860-522-WTIC, 1-800-966-WTIC. Bob in Enfield, you hold on, and we'll get to you in a little bit. Okay, Carmine, before we broke, we were discussing this business about Aunt Tilly, about the fact that a will contest was necessary. You laid out the different grounds upon which somebody who's inclined to do so can attack a will, only after they've determined that it's really going to make a difference for them if they're successful. Tell us about what you meant in this phrase, testamentary capacity. What does the phrase mean, and how do you prove that somebody had or did not have it, and whose burden is it to prove it anyway?
So testamentary capacity is one of the actually lower burdens of proof to establish under Connecticut law. It's does someone understand the nature and objects of their bounty, and maybe put a little more simply or clearly, do they understand what they have, and do they understand
their next of kin?
Exactly. So it's a very low burden to establish that someone knew what they had and knew who their next of kin were.
So would it be fair to say that I may be too far gone to make a valid contract, but I could still have the requisite testamentary capacity to make a valid will?
Yeah, that's a wonderful question. So the capacity to execute a contract is much higher than the capacity to execute a will. And the way that I usually say that to clients, and even when I'm in court, is when you're executing a will, really the question is, do you understand what you're doing in that moment? Whereas when you're executing a contract, it's not only do you understand what you're doing in that moment, but also the consequences of what you're doing in that moment in the future. So the difference between present when you're executing the will and present and future when you're executing a contract.
I think that's an excellent point to keep in mind. We're going to follow up on this a little bit further, but we are going to go to Bob in Enfield. Bob, hi, you're on Law Talk.
Hi, how you doing? Thanks for taking my call.
Good, thanks. I understand you're a little bit off topic, but we're going to try to help you if we can anyway. So this has to do with a security deposit?
Yeah, sorry about that.
That's
but
okay.
I'm kind of desperate.
We're here to help.
In South Florida. She survived the hurricane. And she just got a new landlord for her apartment who's never seen her place. And the simple question he asked her to do was to, could you just, put some plywood over the windows, for the storm? And I guess he totally snapped, and because he's a new landlord, he automatically upped her apartment by $300 for rent per month. So she's getting out. He's never seen the place, and I'm afraid that when they meet at the end of the month, she's not going to get her security deposit back. So if that happens, what's her recourse?
Excellent question, Bob. I've got to tell you, first of all, that this will be governed by Florida law rather than Connecticut law. So I'm going to give you some general ideas, but you're probably going to need to have her double-check with a Florida attorney. And I'm going to tell you how you can do that at very, very low cost after we touch on a couple of points here, okay? First of all, it sounds like she was already a tenant with a previous landlord, and then the ownership of the building probably transferred to this new guy?
Yes.
Okay. Now, that means that if she had a lease with the previous landlord, the mere fact that the ownership has changed does not change the terms of the lease. The successor landlord is still obligated to honor the terms of the previous lease. Second point would be with respect to the security deposit. Those are typically either assigned or adjusted for when someone or something that owns a building with residential tenants in it transfers the ownership. She probably is still entitled to that security deposit from the existing new owner, unless somebody has told her in writing that the previous owner has retained responsibility for it. Now, here's what you do in terms of getting some Florida advice on this. If you continue to listen, we're going to talk a little bit more in the program about the Hartford County Bar Association's Lawyer Referral Service. Now, this is a program that's built on a national model from the American Bar Association. When I give out this phone number, and I'm going to give it to you in just a minute, you can call them and say you need to find a similar office in the part of Florida where your daughter is located. Where in Florida does your daughter live, Bob?
She's 20 minutes south of West Palm in Delray Beach. Okay,
so I'm sure that they're going to have some program from a local bar association down there, but she's going to get a half-hour consult for an extremely modest fee. Up here it's $25, and there's no further obligation. If she wants to hire the attorney and the attorney wants to work with her, that's up to the two of them. But here's the number that you call locally, and when you call them on Monday, tell them that this involves a Southern Florida matter, and can they hook you up with a similar service in that area, okay? Okay, here's the number that you're going to call. You ready?
Yep.
Okay, it's 860.
860?
525.
525?
6052.
6052.
Right. Okay, but that's the best way to get some Florida-specific law regarding her rights as a tenant. But I think you'll find the law is probably going to be very favorable towards her, because the fact that her previous landlord transferred ownership to someone else doesn't excuse the obligations that the landlord has, nor does it extinguish the rights which she has as a tenant. But thanks for calling, Bob, and let us know on a future show how it turns out, okay?
Okay, thank you.
Take care. Bye now. Okay, our phone number is 860-522-WTIC, 1-800-966-WTIC. We're here until 4 today. You're listening to Law Talk on WTIC, News Talk 1080, WTIC.com. If you're away or if you know somebody outside the listening area that may want to join us, WTIC.com, follow the prompts to listen live. We occasionally get calls far removed, and we're delighted to hear from them if we can help them. Okay, getting back to our topic here, we're getting ready to challenge Aunt Tilly's will, drafted 6 weeks before she died, leaving everything to that nameless televangelist TV preacher that she decided was going to get the entire estate that Aunt Tilly had. We talked about testamentary capacity. You said there were a couple of other grounds, something called undue influence. What's that? How's that work? Does it apply in this case?
So undue influence occurs when somebody exerts some influence over, in this case, Aunt Tilly, which would, but for that conduct, she wouldn't have signed the document in the first place. So in other words, that person is beginning to handle all of her mail, handle all of her finances, start to do everything for Aunt Tilly, so she becomes
Make
reliant.
Aunt Tilly dependent upon that person.
Right. It goes from dependence to then isolation, and that complete reliance then. And the next thing you know, that person goes from just being merely an acquaintance to a friend to a trusted, or purportedly trusted, and then they're the beneficiary of the will. Now, to apply to the Aunt Tilly hypothetical, undue influence might not be one of the theories in our case here, because the televangelical preacher, I'm not sure what state that whether we established that, but that might be difficult to show that he or she unduly influenced Aunt Tilly through
to the point where she became dependent upon him for something.
Exactly.
Now, let me change the hypothetical just a little bit, okay? Supposing Aunt Tilly's got 3 children, and one of them is a daughter who cares for her and helps her with her banking, and as time goes on, maybe gets more and more, shall we say, ambitious about what she's doing for herself with Aunt Tilly's assets. And the other 2 children, upon Aunt Tilly's death, realize that this daughter has been favored substantially. Does undue influence apply in circumstances like that?
Yes, unequivocally.
Okay.
And you have what you look for is, and there's cases out there. One of the cases I usually cite is the Pickman case, and it talks about, is someone susceptible? So what we'd want to know Aunt Tilly's condition at a certain time, or at around the time she purportedly executed the document. Is there a result reflecting undue influence? Was her long-time estate plan to all 3? And then shortly before she passes, it goes just to one of the 3.
Is Aunt Tilly required, in our example here, to treat all 3 of her children equally?
No.
Okay. I think a lot of people might have that impression, and from what I understand, that is not the law.
You're dead on, and that comes in that call a lot too. We were all supposed to be treated the same, and we now have the will, and we weren't treated the same. Therefore, I want to challenge.
We're going to have to break in a minute or so, and on the back half of the program, maybe we'll talk a little bit about what are called lifetime transfers also, because I think that this undue influence stuff applies to that. But before we do that, though, because undue influence wasn't going to apply in our hypothetical with the TV preacher here, and it sounded like testamentary capacity was the issue, you've already defined that for us, but where do we find evidence of that, and how do we put it on, and what do you do when you're representing someone who's attacking a will on the grounds of undue influence?
Number one, you want the medical records. That's pretty critical to see the person's condition. Number two, in a lot of the will contests, you have a expert, a doctor, geriatric psychiatrist, to testify or opine, so to speak, regarding the medical records.
And I assume that there are forensic people out there who feel comfortable offering opinions about Aunt Tilly's state of mind, although they have not only never examined her or treated her, but couldn't pick her out of a lineup, so to speak.
That is the frequent cross-examination of the expert.
Understood perfectly. All right. I'm getting the understanding here that we're going to be breaking at about 3:30 for news, sports, weather. So let me just remind our listeners that you're listening to Law Talk on WTIC, News Talk 1080, streaming audio on the net, and this is CBS Radio for Southern New England. I'm Attorney John Metoulis from the Hartford County Bar Association. We're delighted to hear from you at 860-522-9842, 1-800-966-WTIC. My guest today, Attorney Carmine Perry from the law firm of Cepeda Daly Pope, and we're going to be back on the backside of the news, sports, weather, etc. Stick with us. See you then.
How many roads must a man walk down before you call him a man? How many seas must the white dove sail before she sleeps in the sand?
Yeah, tell us the answer, Bob.
How many
another chorus. Okay, that's it. We're done with that. Welcome back to Law Talk, folks. In honor of Bob Dylan, of all people, receiving the Nobel Prize for Literature, we've been using a little bit of Bob Dylan bumper music today, so that's the reason why you've been listening to that. First American recipient since 1993. You're listening, believe it or not, to Law Talk. I'm Attorney John Metoulis from the Hartford County Bar Association. My guest today is Attorney Carmine Perry from the law firm of Cepeda Daly Pope, and we're talking about a whole bunch of things that come up in probate court and elder law litigation. Dorothy in West Hartford, we're going to get to you shortly. We've got a couple of lines open. We're only here until 4, so if you've got a question about this stuff, you've got a concern, a problem, a complaint about how something's worked out, our phone number is 860-522-WTIC, 1-800-966-WTIC. I've got to take a minute to let you know that if you need an attorney and you're not sure where to turn, the Hartford County Bar Association operates a not-for-profit lawyer referral service. And I'm going to take just a minute before we get back to the programming to tell you how this works, because it is a great deal compared to the other choices out there. You phone them at the number that I'm going to give you in just a moment. They'll ask you a couple of questions to determine the nature of your legal issue. You then get referred to an experienced, insured attorney who practices in the appropriate discipline to help you out. What do you get? You get a half-hour consult with that attorney in his or her office over the telephone. That's up to you and the attorney. And there's no further obligation whatsoever after that. Now, what does all this cost? There's a one-time only fee of $25. That's it. And that's to help pay the cost of the administrative expenses of running this not-for-profit program. Now, at the end of that time, if you and the attorney wish to proceed further with each other, that's up to the two of you. If you don't, that's the end of the obligation. On top of that, if you call concerning your personal injury case, they will waive that $25 fee. If you call concerning your workers' compensation claim or your Social Security disability claim, they will waive that $25 fee. This is a lot better than finding some stranger on the internet, or if you've still got a phone directory somewhere in the back page of the phone directory. Here's how you access the service. It's the Hartford County Bar Association not-for-profit lawyer referral service. Call them at 860-525-6052. That's 860-525-6052. That is the Hartford County Bar Association's not-for-profit lawyer referral service. That said, let's go to Dorothy in West Hartford. Hi, Dorothy. Thanks for your patience. You're on Law Talk.
Thank you. Hello?
Go ahead. Yes. Don't listen to your radio. Just talk to us on the phone.
Am I on the phone, on the radio now?
Yes, so you have to turn your radio down, Dorothy. Just talk to us on the phone, just
down.
like, there you go.
I'm 94, and
God bless.
have, what do we say, I have the will, the whole thing, trust, I guess. And my son died in August, one of them.
I'm sorry.
And I would like his share to go, his wife, he was divorced, and I would like his share to go to her. He has 2 sons, but I know she would probably turn it right over to him. But she's been so wonderful. I would like to acknowledge her in that way.
That's very kind.
I did fill out a form, which I got, I guess, off something, and I had it signed by friends, but I did not have it notarized. Would that be legal?
Dorothy, I'm going to have Attorney Perry discuss this with you because he's an expert in this area. Carmine, what can you tell Dorothy?
Hi, Dorothy. How you doing? This is Carmine. How are you?
I just explained to him.
Yep.
I'm 94.
No.
Yep, he heard.
I heard you, Dorothy.
Okay,
Yeah.
so what would my...
He's going to tell you what to do.
Yeah. So Dorothy, it sounds like if you have an existing will, or
I do,
okay.
and I called the lawyer to see about them making that one change, and it was going to cost me almost $400. And at my age, I cannot afford it. So I went to that legal Zoom or something and found this form.
Yeah. Well, you can go with whomever you want, Dorothy. That said, it sounds like it's important to you that your son's ex-wife receives something from you. And I think the question in your mind is it worth enough for that $400 to revise that? If it's a will, it could be something called simply a codicil, which is
that's
just...
what I thought, but...
Right. So what I would suggest is you maybe consider that $400 to your attorney and have him or her draft that codicil, which is I guess sort of a fancy word for just an amendment.
Yes, that's all it is.
Right,
Yeah.
and that's your choice, and you can do whatever you like. But it sounds like she means a lot to you, and
she does.
okay, and so I would suggest you consider maybe doing that codicil or amendment, and that would address your biggest issue. It would update your estate plan, and the portion that was going to go to your son, and I'm sorry for your loss, would go to his ex-wife.
Dorothy, earlier in the program, we talked about technical defects in wills. I have a feeling that the codicil that you've already signed may be technically defective based on something that you said to us. So I urge you, see an attorney. Some of them will take credit cards. Some of them may allow you to pay it over time. But please have a competent attorney help you carry out your wishes here because it's important to you, and it's going to be very important that it be done in a fashion that's effective to carry out your wishes. Okay?
Can I go to another lawyer that might be cheaper?
Oh, sure. You can call them up on the telephone and you can inquire on the phone. We're very much in a consumer-oriented legal environment these days.
How about that number you gave me, the 525, and it was 0052?
No, 525-6052.
6052.
Right. We've got some of the calls, Dorothy, so I'm going to have to excuse myself, but I hope it works out well for you. You take care now, okay?
Thank you. Bye-bye.
Right. Okay, Law Talk phone number is 860-522-WTIC, 1-800-966-WTIC. Stick with us if you're going to call. Do it sooner rather than later. Next up, Skip in Bristol. Hi, Skip. You're on Law Talk.
Hi.
How can we help you out, Skip?
I don't think you can.
Well, we have a call.
Probate, how can I tell you this, okay? Connecticut probate is the second worst in the country.
Okay, well, Skip, we're more interested in trying to answer questions or provide help. So if you can give us a question we can answer for you, or if there's something we can do to help you, we'll be happy to.
Question.
Go ahead.
Okay. I do not have a dysfunctional family. I have 3 siblings. I have a dysfunctional sibling. Okay? My father died last year. Now, he set his entire estate up to protect my mother, to take care of my mother. Okay? $880,000 is missing.
Ooh.
Okay? I've been in probate. Now, the last time I went to court, it was in my mother's house. Because my sister is saying she had a stroke and she cannot. Okay? It was ridiculous. Absolutely ridiculous. Okay? So my point is, how can $880,000 that my father put for my mother to take care of her is gone?
Well, Skip, I'm going to turn you over to Attorney Perry in a moment, but I'm going to suggest that you might want to ask the court to appoint an estate examiner or someone like that who can audit what was done.
Okay,
Carmine,
what I have. Let me tell you, it's already been appointed.
Okay, go ahead.
Already appointed is a conservator.
That was when she was alive. When she died, that person's...
No, my mother's alive. My father died.
Oh, I'm sorry, Skip. I apologize.
Right. My mother's still alive. But every time I visit my mom, which is once a week, there's a new caregiver.
Oh, geez.
I'm not in control of that. As I'm not a POA, I'm not a consecutor. So I visit my mom once a week, sometimes twice, but there's a new caregiver. Okay? I don't know what's going on. My sister, who is a POA, lives in Florida. So I am her, I am her, I call her every time I'm there, so she talks
Skip,
to my
Skip,
mom.
may I interject, Skip? This is Carmine Perry. How are you? I think you said there's a conservator. Is there a conservator for your mother at this point in time?
There's a conservator, there's a POA, there's all kinds of stuff going on. All I know is that 3 TV stations want in on this, but my sister in Florida tells me not to do it yet.
So, Skip,
I'm only going to say
Skip.
this to people, okay? You need to get this straight. Please, if you write a will, okay, one person, not 2, conservator and POA, because if the 2 POAs or the 2 consecutors or conservators disagree, you're going to end up in probate court. And probate court is in Connecticut is the second worst in the country.
Skip, thanks for your call. We've got a full board, so I'm going to have to say goodbye. But thank you for your call, Skip. Okay, don't mean to cut the man off, but we've got several other calls waiting. We've got to take a break. We'll be back with Attorney Carmine Perry. Roy in Middletown will get to you. Robert in Plainville will get to you. And I see there's another one being processed. I'm Attorney John Metoulis from the Hartford County Bar Association. Law Talk continues after this. Okay, a little bit of...
Mr. Tambourine Man, play a song for me.
Yeah, that's the last of our Bob Dylan honorarium bumper music selections here. Back to Law Talk. We've got calls waiting, and we're going to try to get them all in before we finish up at 4 o'clock today. First up is going to be Robert in Plainville. Hi, Robert. How can I help you?
Yes, please. I have a question for you, and that would be that my mother passed not too long ago.
I'm sorry.
And there is a wrongful death suit in process. So the will was clearly written that my brother and myself were heirs to the estate. Now, there was nothing left when my mother passed away. Everything was liquidated and gotten rid of so that my mother could qualify. And if I believe it's Title 19, where the state would assist in her living in a rest home.
Yes.
And now the state, so we've made an estate for my mother. I did, acting as the executor, I guess it would be. And now the state sent a letter saying that you owe X amount in fees which were paid to the rest home. So my question would be is that it seems like they're kind of wanting to see the will because they want to make sure that the language was clear, that my brother and I were heirs to the estate. There's no question in that. But, I mean, is the state entitled to get reimbursed for a wrongful death suit?
I'm going to turn that over to Attorney Carmine Perry.
The estate is entitled to reimbursement. It's an estate, it's a lien, and we see this when there's an estate that there's nothing in it, a testate estate, or an insolvent estate, but when there's litigation pending. So in this scenario, it sounds like your mom was of modest means. She qualified for Medicaid, but then you have this wrongful death suit. I don't know if has there been a verdict or a settlement where there's now monies available, or is the state just putting you as executor of the estate on notice that in the event of a verdict or settlement, it's going to want its lien satisfied?
Okay.
Well, so that was a question, and I know it's more for me to answer than to question you. It's just a question. Are there monies now in the estate? And if there are, then the estate is saying, hey, we'd like to be paid. We'd like our lien satisfied.
Robert, this is John. Let me offer a thought on this because I went through this exact case a year ago with an elderly fellow that was run over by a bus and died. And his estate, he wasn't on Medicaid, but he owed the state some money from a previous benefit that he'd received. Tell your attorneys before they settle this case to negotiate with the Department of Administrative Services about that lien, because if the case is not a real strong case and it's going to be compromised, you may be able to compromise the size of the lien also and leave something for the beneficiaries. The strongest argument they can make is to the state, if you're going to enforce your entire lien such that it wipes out the recovery, the estate has no incentive to pursue this litigation. We'll just drop it. You get nothing. So if we can compromise it, the state will get something towards its lien and the beneficiaries will still be able to get something. So I just wanted to pass that along for what it's worth. Carmine, before we go any further with someone else, anything further we can tell Bob in Plainville, Robert in Plainville?
No, I think that addresses it. It's that question: is there money? And I would talk to, just as John said, talk to your attorneys and see what that lien is. And even if it is compromised, it may help both parties: the estate itself, which is your brother and you, and the state.
But tell them to do that before the claim is settled by negotiation, because it's a lot easier to tell the state, look, this case is not as strong as it might be. There's all kinds of problems. There's going to be a lot of expenses. You can get them, at least in my experience, if you have a good, solid, well-documented basis for doing so, to agree to compromise the recovery in advance, especially if it looks like there may be very little or the case may be losable for whatever reason. So I pass that along for whatever it's worth, Robert. I hope it's helpful, and perhaps in the future you can give us a call and let us know how it worked out for you, okay?
Okay, I do appreciate your time in this. Thank you.
Thank you for calling. Okay, we've got a little bit more time left. I want to touch on a couple of other things that are really important. Roy in Middletown, if you want to hold on with us, we'll talk to you off air, but there's a couple of things that Carmine wants to make sure that our audience is aware of. Carmine, let's jump to the convalescent home nursing facility type of situation. And we'll go back to Aunt Tilly. We're resurrecting her to use her as an example. She was living at home. She's failing. She's no longer able to live at home. So I'm taking Aunt Tilly to the nursing facility, and we're signing all the paperwork to have her admitted. What is the single most important thing that I need to know in connection with that process?
So in that example, know what you're signing before you're signing it. A nursing facility admission agreement is a contract. With it, there are various terms, and within those terms, one can be held personally responsible for a purported debt owed to a nursing facility.
You mean because I brought her there and I'm her relative, that if I sign the wrong papers, they can hold me responsible for the cost of her care?
The answer is yes to that.
Okay.
And despite, in some cases, you're being told otherwise. And my first case ever was a person who brought his aunt, and he was just off that day, and he was advised that you're just signing for contact purposes, and then he was sued.
Okay, and that, ladies and gentlemen, is an extremely important thing. If you take away nothing else from this program today, that by itself is worth taking with you. And that music in the background is my cue to say thank yous, and it's time to wrap up yet another Law Talk. So first of all, thanks to my guest, Attorney Carmine Perry from the law firm of Sapega Daly Pope. Thank you for joining us on this beautiful Saturday afternoon. Thanks also to Kevin, our producer. He is the gentleman that you hear when you call in, and he has the unenviable task of trying to make us sound good on this program here. I'm Attorney John Matulis from the Hartford County Bar Association. Have to remind you that the football game tonight, 5:30 p.m. pregame program right here, WTIC News Talk 1080. Go UConn, and we'll see you all real soon.
Law Talk is presented as a public service by the Hartford County Bar Association. Its content is intended to be educational and informative, but is not considered to be formal legal opinion. If you want or need formal legal opinion upon which to rely on decision making, please consider formally engaging an attorney to review all relevant facts in detail and examine the pertinent laws that applies to those facts. A solid opinion means better decisions. The views expressed during this program are those of the speakers and not necessarily those of the Hartford County Bar Association, its officers, or its directors. The opinions and advice expressed on this program are not necessarily those of WTIC. Please consult your own legal advisor for further details.